Good morning, everyone, and thank you for joining us on this panel that's going to discuss consumer claims and consumer protection. So my name's Simon Pugh. I'm a partner at Portland Communications, where I provide media and communications advice to clients and their legal teams, including on both the defendant and claimant side of group litigation. And I'll let my esteemed panel introduce themselves.
Kenny Henderson, I'm a partner with the CMS, got a particular focus on class actions. Thanks, Andrew, for the plug for our class action report earlier on. We've got a few at our stall outside if anybody would like to grab them. We advise clients in defending cases, both in the jurisdiction where claims are filed, but also with a view to pan-European risk as well, as these cases do have an increasing tendency to proliferate.
Morning, everyone. My name is Matthew Angelus. I'm a partner at Torys LLP in Montreal, Canada. Torys is a full-service business law firm with offices in all the major Canadian cities. My own practice is focused on consumer protection, which means two things. First, I defend corporations in consumer class actions, which are launched in Quebec, Quebec being Canada's French-language civil law jurisdiction. And second, I do consumer protection regulatory work, primarily for companies who are coming into Quebec, looking to understand how to do business and respect consumer protection regulation and legislation in Quebec.
Morning, I'm Tom Hunt from Aon's litigation risk group, based here in London. We're a global team and a full-service insurance broker and advisory firm. We work with both claimants and defendants, but my primary focus is supporting lawyers and claimants, protecting adverse outcomes to litigation.
Brilliant. Well, thank you very much. So Portland produces a report where we poll consumers both in the UK and the US on class actions, and we've launched this report today, so I think there's some copies available. But I thought I would start by just pulling out some of the kind of key findings from that report as a bit of a scene setting for this panel on consumers. So one of the things we find is that consistently there is a pretty low understanding of class actions in the UK, so only 19% of people claim to understand them, and that figure sort of has never really gone above 1 in 5. Consumers in the UK are, however, quite willing to join class actions if they were eligible, so 64% say they would join. And 23% of people in the UK say they have joined a class action, and that's jumped quite a lot from 18% last year, which is perhaps not unsurprising given the number of actions that are now live. One of the other things we typically see, and apologies to Walter and Tom Clark, from which this will probably annoy you based on yesterday's panel, but 63% of consumers say that they view litigation funders and lawyers as the principal beneficiaries of class actions. But I think you are very right to say that as more settlements and damages start to come through, that probably will change. And to all of the litigation funders in the audience, this year we've seen both an increase in media coverage, an increase in awareness, and an increase in the understanding of litigation funding as a kind of necessity to bring these big claims. So whether that's happening organically or whether you are making a concerted effort to tell your story, it does seem to be working. 56% of the people we polled say that they don't believe class actions will, or say they believe class actions will rarely or never win compensation for consumers. And 57% of people don't believe they are an effective way of holding companies accountable. And that's where I kind of wanted to start the discussion today, by effectively asking whether the panel do believe that class actions are a way of actually protecting consumers. So perhaps, Tom, I'll start with you.
Yeah, so with my claimant-focused hat on, I would say absolutely yes. They are the way to hold corporates to account. As we've seen over the past decades, there's a massive damage to consumer confidence. We can go back to Plevin, PPI scandal, all of those claims that were brought, appreciate not under this regime. We've also had Dieselgate and many other examples where consumer confidence has been damaged and recourse has been brought against the corporates. So I can see that they are an effective way to hold corporates to account.
Kenny, what do you see on the defence side?
Perhaps unsurprisingly, I take a slightly different view. I think there are basically three policy rationale for having class action systems. One is for access to justice. The second is to disincentivize corporate misconduct. And the third is to make collective proceedings manageable in terms of the court system. And we hear comments coming out of the German judiciary about the volume of individual diesel claims going through the German systems, and that is a problem. So those are the three policy reasons for having collective redress systems. But focusing on the first, which is the one that is most about consumers and collective and access to justice, I think the jury is very much still out. We haven't had any settlements in the UK, and I'm talking here about opt-out mechanisms. That's my focus, because opt-in is quite different, where people have chosen and elected to join a claim. So the distribution levels that we're going to see, and we've got the first settlement coming through on RoRo, which will be before the CAT, December this year, the actual distribution levels that we will see in that, if the money isn't going to the consumer class, then that's not access to justice, it's something else. There are other justification. Data from the US aren't promising. The Federal Trade Commission did a study a couple of years ago looking at levels of distribution in consumer class actions and saw that just the distribution level to the consumer class was just 9%. The mean distribution level, 0.9%. Which is not great. Now, we know that the, many of the people speaking yesterday on distribution levels and payment services have got innovative techniques and are doing their very best, and I think the numbers are improving, but they are low. We've yet to see it in the UK, but to my mind, it's very questionable as to access to justice.
I'm not sure I agree with Kenny on that point. As part of my regulatory practice, the first question that comes to mind, and the first question that I'm always asked is, I have an unhappy customer or an unhappy group of customers, am I exposed to a class action? And then the follow-up question, of course, is what do I need to do to reduce my class action risk? Now, I'm from a jurisdiction where class action, specifically opt-out class action, is not just quite popular, but widely used. There are several hundred new class actions which are filed every year, and several, at least, a high number of those ultimately go on to trial. Now, Quebec has both a very liberal consumer protection regime and a liberal class action regime, which means that in the case of basically any breach, the answer is yes, there is some kind of exposure. And these two acts obviously work together. If only one of them is strong, the enforcement regime is probably going to be less benefited as a result. In yesterday's panel involving Walter Merricks, Thomas Clark, and David Curry, the question was asked, does the threat of class actions lead to action in the C-suite? Are people actually worried about the threat of class actions, or is it more of a rounding error, I think was the expression that was used by Thomas Clark yesterday. I can say unequivocally in the Canadian context that the answer is yes, that it does impact, how people and how corporate executives view the risk vis-a-vis the consumer. There are times where class actions follow legislative action. You can think of any number of consumer protection claims which are launched in relation to existing legislation, but there's also times where class actions are actually driving the ship and they lead to legislative change. And two examples come to mind in the Canadian context. First is the Apple case regarding forced obsolescence, which there was a class action instituted in 2017 regarding the practice of, or the fact that phones became more slow with time. This was a class action that was authorized back in 2019, still working its way through the courts, but was followed up first on the continent here, on the European continent, and ultimately in Quebec as well, with a law specifically targeting forced obsolescence. Another example in the Canadian experience is the foreign exchange class actions. Canada is a federation, so the powers are split between the central federal government and the provinces, with banking being a strictly federal power. Well, to resolve the foreign exchange class actions, the Canadian Supreme Court had to answer the question, do provinces also have a role in consumer protection? And the answer was clearly, was a result, yes, that in addition to the federal banking power, the provinces also have an ability to regulate banks. which as soon as that judgment came through, the provinces basically raced to adopt their own version of legislation to respond to that action and to also have their say in regulating banks.
I think just going back to Kenny's point around access to justice, so, you know, insurance products we work with, for example, after the event, that was designed in its purest form to support access to justice, and that is still very much the case today. Across the UK, across EMEA, unfortunately not in the US or Canada because the adverse cost regime, but in its purest form, it is there and has been doing so for decades. So because obviously there are now more mouths to feed, these actions are supported by funding, and ultimately they probably wouldn't get off the ground without funding and ATE. I can see where the kind of erosion of damages comes in, but ultimately it's still required and it does support access to justice for consumers.
Thank you. One of the other things we ask the public about in our research is what they perceive the risks to be when they join a class action. And only 18% of people say that they think there are no risks at all, which is perhaps a slight divergence from what you would take if you read the kind of average claims websites. Unsurprisingly, the kind of number one perceived risk at 58% is the idea that you might have to pay the other party's fees if you lose, and 51% is that you have to pay your own side's legal fees. So I just wanted to sort of slightly flip this panel, or flip the topic on in its head really, and ask the panel whether joining class actions is totally risk-free. And if the answer to that is no, how can consumers protect themselves when they sign up to join a class action? So, Kenny, I don't know if you want to kick off.
Yeah, again, I would draw the distinction between opt-in and opt-out, and the primary risk is, of course, of paying adverse costs. So for the non-UK lawyers in the room, in the UK we have a very strong cost-shifting regime. It is uncapped. There are exemptions, such as personal injury claims and employment claims often do not have cost-shifting rules that follow, but generally the position in litigation is that the losing party will pay the majority of the winning party's fees. It's a distinction in opt-out because the opt-out representatives who definitely walk the walk, no question, they have the adverse cost risk. But when joining opt-in, those individuals who elect to join a claim, they bear adverse cost risk. And I think protection comes in two forms. One is awareness of the risk to ensure that people are choosing to join these claims. And this is a matter of consumer protection. Typically, where we talk about consumer protection, we look at it through the lens of redress against a corporate. But consumer protection also entails ensuring that the consumers who join these claims do know what they're getting into. So one is about awareness, and secondly is about, well, AT and the like, and I'm sure, Tom, you'll have some comments on there. And there has been at least one case where there's been judicial commentary following a securities claim against Lloyd's TSB that essentially did not succeed. And there were judgments around the costs following that, and the ATE wasn't sufficient. And this is sharp and blank. And the judge on the cost matter, Sir Andrew Norris, observed, and he said he questioned whether the 5,800, these were retail investors, retail security holders, individuals, if they joined the claim, whether they thought that they were litigating risk-free, and that's not the case. So there's a genuine issue in terms of consumer protection on the claimant side as well.
Tom, I don't know if you want to pick up on the role of ATE in helping protecting consumers.
Yeah, so kind of the process that we go through. So at a very early stage, we're engaging with the lawyers, we're engaging with maybe a funder who's involved, and we're really working to create, as a broker, a solution that protects consumers' interests from day one. And so that is kind of supporting any expert evidence they may require, kind of taking the risk off the table for that, and ultimately, if there is any adverse cost exposure at the end of the life of the claim, then the ATE policy needs to be sufficient to meet any cost order. Now, we have obviously had examples where ATE is insufficient, insurers' appetite isn't unlimited for these risks, and there's a long vetting process that takes place from funder, lawyer, broker, underwriter. So these claims take a long time to get off the ground. And everyone hopes at the start that sufficient funds have been put in place to protect the client. But ultimately, unfortunately, there have been some scenarios where there haven't been. But we can go on from there. So.
I think there's a lot that individual forum rules can do to reduce the risk for consumers. Obviously, there's a strict cost-shifting regime here in the UK, but the Canadian context, which is different from one province to another, gives us maybe some insight into how to reduce that risk for participating, especially in a world where most of the claims, or virtually all the claims, are started as initially as opt-out claims. So, for instance, in British Columbia, which is one of the more consumer-friendly regimes in Canada, it's a no-cost regime for class actions. And this is one of the reasons why more and more class actions are going into that jurisdiction. But it means that there's no consumer who will be on the hook in that action. Very similarly, in Quebec, individual members of a class action pay nothing. And while it's, in theory, a loser pays model, those costs in Quebec are limited to only a small number of things like court filing fees and transcriptions from depositions. We're really not talking about large-scale cost shifting, especially in a regime where you, or in a setting where you have possibly thousands, even millions of members as part of a single class. Canada's biggest province, Ontario, does have a more traditional adverse cost regime, which is similar to the UK in consumer matters. But even practically speaking there, it's theoretical for most class members. The reality is that in order to enforce an adverse cost judgment in the consumer context, a company would be forced to sue on an individual basis each one of its own customers. In reality, it just won't do that. And so these questions, which are very live in some places, by adopting forum rules, they can be very easily addressed.
I really agree. Local rules are very important in this area, and in terms of, obviously I'm portraying a defendant position here, but for the credibility of the system requires adequate consumer protection. So the claimant side have an interest in this as well, and it's a little, particularly when you're dealing with consumers, particularly when you're dealing with opt-in, it feels to me a little bit anomalous that if you take out a credit card or home insurance, you get it's quite regulated. You get an FCA fact sheet, very specific, clear information to ensure that customers are signing up for these consumer products that have no downside risk other than clarity over what the interest rate is. You're buying a product, you're buying a service, but and the legislation requires and mandates very prescriptive information being given to people before they make that decision. It feels a little bit incongruous that we don't have that in this jurisdiction as well, where there is downside risk to joining these claims, that the importance of giving clear information, because there is a tension on the book build side, of course. It's certainly at the initial stage, it's not the same as B2B litigation, where you've got a large corporate that's being advised on taking, on the claimant side, very aware of the risks, and it's got a lawyer giving them specific information on this. On the book build side, of course, the claimant side are wishing to ingest people to encourage them to join claims. It's not the same relationship as giving B2B information. So there is an area there, I think, that should be explored about giving information. I mean, some may say, well, why don't you get rid of adverse cost rules for these sorts of claims? But of course, adverse cost rules are very important to disincentivizing unmeritorious litigation. And back in 2012, when the UK government were consulting and bringing the competition class action mechanism, the consultation paper, said, don't worry, we're not going to bring over the US-style class action litigation. So there are checks and balances that I think should be remaining in the UK.
Great, thank you. We've heard a lot over yesterday, and I think there'll be more today on sort of ESG and how that's becoming more of a kind of prevalent feature of both this system, but kind of litigation and generally kind of consumer perception more widely. Again, we asked kind of consumers when we're conducting our research about this, and what we see is there is a kind of real increase in support for consumer activism and generally kind of activist behaviour on the part of others. So 46% of people regard shareholder activism to be a positive versus only 10% who don't. And unsurprisingly, given all that's kind of going on in the world, we see climate change as a kind of particular pressure point that consumers are concerned about when they support shareholder activism. 62% of people think that company directors themselves should be personally liable for a company's ability to kind of manage climate change risk, which we see the Client Earth Shell case took a setback on its merits, but actually it does appear that there is kind of quite widespread public support for that. In terms of what actions consumers themselves would take, 68% of people said they'd be less likely to buy shares, 65% of people said they would boycott a product or service from a company facing a class action. And quite interestingly, 62% of people, which I think is actually very high and has made quite a substantial jump from last year, say that they would quit their job or not apply for a job with a business that was facing a class action, which I think is quite a staggering statistic. So I wanted to kind of ask the panel, when you are, and I'll start with the kind of on the defendant side, when you are advising clients on their legal strategies, how do you marry up the strategy of kind of what goes on in the courtroom, the pure legal strategy, with some of these kind of other risks to businesses when they're facing a class action, particularly when the claimant side will obviously be seeking to use these pressure points as a kind of point of leverage. Matthew, I don't know if you want to start there.
Sure. I think one of the most significant ways to manage, I think that risk actually needs to be taken in context. Coming from a jurisdiction where class actions are regularly authorized, the threat of an authorized class action is quite a bit less, or the perception of an authorized class action is quite a bit less than it was in the past. In an environment where there are only a few class actions which are authorized, or certified, I should say, there's a lot of attention that are drawn to those individual claims, but when they become so regular and so part of the news cycle, that threat of an action causing what would be a PR nightmare, just having the word go out that it was authorized or certified, today is quite a bit less in the North American context. It enters the 15-minute news cycle, and just as soon as it enters, it's then gone. But with all that being said, the threat of a merits decision is still very real, and the question of how to manage that risk does definitely require a coordinated strategy. First, you might see actions that are filed in multiple jurisdictions. Important to consider how those actions might look in those different jurisdictions. Even within a single country, you might have an action that's launched in 3 or 4 different provinces. And the first goal will be to try to at least stay or suspend some of those actions so that you're only playing chess on one chessboard and not 3 or 4 or 5-dimensional chess on a number of different boards at the same time. Even if that means compromising some elements of the claim, and it's important to always keep in mind that what works in one jurisdiction may not work in another, and keep that on a more broad focus.
Yeah, just to add a few observations on top of that, these are complex projects where you're looking at potential litigation across multiple jurisdictions, threatened litigation as well, potential regulatory action and investigations. Corporates are also very concerned by reputational risk as well. And so there's this kind of combination of factors that will drive decision makings, but you really have to very quickly identify a couple of things. So what are the areas of key risk? What is really going to move the needle in terms of overall exposure? And also the facts. You've got to get on top of the facts very, very quickly. And just like every class isn't the same, every situation on the defendant side isn't always the same. Sometimes when a class action is filed, the defendant will be fully on top of the facts. It's information already known to them. But we've touched on, in a couple of other panels, kind of competition type claims. And where you've got a cartel is typically concealed from the business. This is not conduct that's mandated by the board. Let's go and form a cartel. Traditionally, they have been driven by bonus structures and individual incentives, and people in the business will take steps that they shouldn't be taking. This leads, when companies apply for leniency, it's often because somebody within the compliance function finds out about this, and it's very quickly escalated, and you've got a prisoner's dilemma to quickly go and tell the regulator, look, leniency applications are down now. So again, the situation for the defendant differs depending on the facts, but it's not, you need to get on top of that very, very quickly and identify which are the highest risk areas. And one benefit of opt-out class actions, I would not want to overstate it, is that risk is crystallized for the defendant. They know the size of that problem, at least in that jurisdiction, so they at least have visibility and knowledge of that.
And when you're, when you're working with a GC on an issue of this type, how do you kind of help them to sort of manage some of those kind of wider pressures that they may face that are kind of slightly outside of the pure legal strategy, but kind of still a threat to the business?
I'm a great believer that decisions are taken by individuals, by people rather than companies, and people within companies. And so the GC will be very concerned by questions from the board. They will be very concerned by, what's the board going to ask me in the short term? What's the plan? When there's media coverage, what do we say about this? Because that's when they will be facing questions. So at the start, you've really got to very rapidly get your arms around and support that element, and then have your staged plan beyond that. So you've got your proactive, this is what we're doing, and reactive in relation to short term. Because in that scenario, at that stage, it really is just crisis management. Mm.
It's also important, and I'll just touch on this briefly, not to overreact to a situation. A claim comes in, it's very tempting to say we're going to do this, 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 and this. A class action is long. Class action might take a couple of years to get to certification, and 6, 7, 8 years after that, and the facts can change over that time. So it's important to take the time to make a decision, get it right, so that you're not affecting your litigation strategy for a case that's going to last a decade, with a decision that was made in a week to try to get something done quickly.
Yeah, and from a kind of a PR and media relations perspective, that conversation is something we have with clients on a kind of frequent basis, where there is always that kind of urge to say something very quickly. And actually, it's far more effective to take that time to kind of get your ducks in a row, and as Kenny said, to sort of establish the facts before you go out and say something that you'll later kind of find causes you all sorts of problems. Tom, what on the kind of insurance side can be done to help manage some of these wider risks?
Yeah, thank you. So put my other Aon hat on. So Aon has a huge corporate client base. We have a number of products that can help corporates when thinking about class actions, thinking about any adverse judgments that they may be facing. So firstly, I want to say that insurance is not designed to support bad behaviour and insure bad risks where there's a guaranteed likely payout, because the defendant may have been involved in things they shouldn't have been. However, where, for example, a client is facing a transaction and they may be a subsidiary of a company that's involved in a class action, but that sale is being prevented from happening, we do have a product, and we work regularly with our M&A team in relation to a product called adverse judgment insurance. So when there's an unmeritorious claim, maybe an overvalued claim, and that is affecting a transaction completing, then we can actually provide cover up to the limit of the amount that they may be facing to pay out if a judgment was against them. And as I stress, it's unmeritorious and typically overvalued. And we're actually working on a European example of this at the moment, where a large corporate client is selling one of its subsidiaries, but is being prevented from doing so because it is wrongly, in their opinion, been brought into a class action. So that's where insurance can help. As I say, it's not a silver bullet for defendants to go and purchase this massive limit of insurance. However, it is possible. And the other side of things as well is D&O. So obviously that protects directors and officers. So I would advise that whilst I'm not a specialist, corporates should be making sure there's no gaps in cover. Personal liability of directors is covered as much as they possibly can if there are actions brought against them.
And just finally, before we wrap up then, what, kind of looking to the sort of future, what do you think are some of the kind of emerging trends that both claimants and businesses should be aware of that are kind of coming down the track? And Matthew, maybe we'll start with you as a sort of our representative from a more established jurisdiction. What do you see?
Sure, and I'll temper, I think, one of Kenny's comments where he said there might be an advantage to a opt-out regime.
I'm very cautiously considering this.
One development which we've seen over the last couple of years are copycat claims. In Quebec, where I'm from, which is a first-to-file jurisdiction, which means that there are no carriage fights. It's really the first plaintiff's firm to file a class action that will get to run with the baton unless there's something that develops later on, a conflict or some way that the case was mishandled. And so subsequent claims which are filed, or subsequent class actions which are filed, are stayed pending the result of the first one. But what we've seen develop over the last couple of years is a trend of copycat litigation, where once a firm has brought a class action, had it certified or authorized, and carried the ball a good deal of the way, getting it close to trial position, a rival firm files a very similar claim, claiming essentially the same bucket of damages, but for a very marginal different breach. And I'll give an example of a banking claim where it's alleged that a fee has been misrepresented. Well, as we're getting that case close to trial, all of a sudden another plaintiff's firm swoops in and says that in addition to that fee being misrepresented, it was also illegal for some other reason based on some consumer protection legislation. And this practice raises concerns for both the plaintiff and the defense bars. On the defense side, companies are obviously concerned with paying twice. If they've been through a settlement or through ultimately a trial judgment required to refund an amount as part of a class action, as part of the first action, I should say, well, what happens with the second one? Are they going to be asked to refund twice? That's a significant concern on the plaintiff side, in addition to having to defend the same action twice. But on the plaintiff side, plaintiff firms are also concerned with their fees. The firm that carried the ball the entire way, did all of the legwork, finds itself all of a sudden with a second player in the industry. In Quebec, it's relatively common to see contingency arrangements where the plaintiff's side gets 25 to 30% of a settlement or a judgment envelope. Well, if all of a sudden you have a second firm in there, how do you make that firm go away? A lot of the time, plaintiff's firms are forced to, one way or another, compensate the second firm, and they've started to call that paying the tax, which raises a lot of questions as to not just procedural fairness, but how do you actually deal with this situation arising?
Kenny?
So for me, just looking ahead, crystal ball gazing, for corporates, probably the three biggest things to keep an eye on are, first, obviously, the rise of opt-outs becoming more available in different jurisdictions in Europe. Second, the increasing globalization of this topic, which I've nodded to already, the fact that the plaintiff bar and funders increasingly coordinate. And we talk about forum shopping, but actually, again, another feature of most of the European opt-out systems, the opt-out class is restricted to those people domiciled in that jurisdiction, and if people want to join from outside that jurisdiction, they have to opt in. So to the extent that that holds true, there isn't really forum shopping on opt-out class actions. You can only bring an opt-out claim in the jurisdiction of the people you wish to coalesce. So yes, the increasing coordination on the plaintiff side means that these cases and these problems are increasingly globalized, so the corporates need to have a proliferation strategy and a reaction strategy. And number three is to keep an eye, because obviously we're very focused, UK practitioners are very focused on what happens in the UK, but our clients often will have a MIA responsibility. The lawyers are coping with. And what's coming out of Europe is significant as well. We're seeing more and more draft legislation that's actually moving the needle on substantive law and risk. So the Product Liability Directive, the Draft Product Liability Directive, is moving the needle in terms of burden of proof. These are really small changes in sentences and legislation that have got a huge impact on litigation risk. So there's a number of pieces of draft legislation coming out of Europe that are really moving the needle in terms of litigation risk that corporates need to be aware of.
Yeah, I would agree with that. Just on the European point, Aon's litigation team have been involved in roadshows across all major European cities this year, speaking to defendant and to claimant law firms. The number one thing on the agenda when we talk about litigation risk is class actions and how we can support them from both sides. Obviously, not all jurisdictions have an adverse cost risk, but particularly in Spain, we're seeing lots of action, lots of kind of inquiries. Portugal, we're seeing inquiries from there, even though the adverse costs regime there is kind of a little bit more limited. And obviously, as we've discussed and heard earlier, Netherlands is deemed a destination for these actions. What I want to say about the UK as well, and certainly things that we're seeing at a very early stage, is a rise in securities litigation, so Section 98 claims. We're also seeing cartel allegations, maybe things that have been already in the news and maybe have been investigated by the DOJ and settled over there, but European Commission is still very much in their investigation phase here. So there's still lots to come, and yeah, we, as Kenny said, what I've seen over the past 10 years is an increased sophistication from the funders, the insurers that support these claims, and the lawyers, and that's, you know, just bringing everything closer together to bring these claims on behalf of consumers. So it's not going to slow down, is my view.
I think we can all agree on that. We've got 3 minutes left, so I don't know if there are any questions from the audience.
Hi, Tom Clark from Which. Good to know that everyone was listening yesterday afternoon. Thank you very much, everyone, for a really engaging session. I wanted to take things back to deterrence because it is something that we touched on, you touched on. And Matthew, you talked about defendants coming to you where something has happened and they want to talk about their risk of a class action, you know, following along from that, and presumably then also the PR reputational issues that also can follow. I guess the question I wanted to ask is, are they doing that, and presumably once there is an infringement, once something has happened, or are they also, are they also thinking about these things prior to there being an infringement, prior to something happening, and proactively changing their behaviour as a result? So it's really just trying to get at, well, if we're talking about deterrence, real deterrence is that these infringements don't happen in the first place.
Right, and so thanks for your question. I would say it happens in both cases, but specifically yes to the second situation. Companies proactively are seeking to not just comply textually, but do so in a way which makes sure that there's no risk of breach and no risk of things going sideways. And one of the examples that I gave was the FX decision, which led to a series of provinces adopting action. Over the years that followed, one company after another consulted to see how best they can adopt to this new world where they have legislation that may not be that different from what the obligations they already had, but an entirely new legislative scope and sort of a different playing field that they would have to play on.
One thing that we are starting to see a little bit on the kind of reputation side is how the kind of financial markets can potentially kind of drive corporate behavior as well. When you see you see kind of big institutional funds talking more and more about kind of ESG or ESG kind of ranking agencies. I mean, I still think it's very early days in that, but I think as potentially more ESG theme focused claims are filed, there might start to be sort of pressure in terms of corporate behaviour driven through that direction as well. Any more questions? I think we've got 3 seconds.
I'll make it fast. Yana Hart from Clarkson. My question is more for Kenny. How prevalent are pre-litigation resolutions of cases, especially based on consumer claims in collective type of actions?
I think pretty limited. I think it behoves claimant and defendant side to try and create a safe space if you want to have pre-litigation settlement. But it would depend on the scenario, really. But it's quite limited because a big concern in any settlement is encouraging further litigation, and the overall risk environment needs to be looked at. It's quite hard for these things to be kept confidential. Again, B2B, it's easier, but where you've got consumers, it's very hard.
Well, one thing that we do see a lot of resolution pre-certification, but not pre-filing.
Yeah.
So you can avoid the class action. You'll end up having the class action certified for the purpose of settlement, but it still will have been filed before you get there.
Not to forget that corporates often have very good defences and may not have done what they're being accused of.
Right, on that note, I think we are out of time. Thank you.
Thank you.